item number 2. It is RDB with Arjuna Veterans. Item number 2.
No two. We'll take it up in the first up. Don't mention all these matters. No mention. First up means first item. One. One I'm taking one, then two, then three. Then...
Half an hour or
Okay.
apply.
May be the Lordship. Lordship, I beg to mention one RSA Lordship. In this case, status quo was granted, and Lordship, we have later on filed violation, Lordship. In violation also, they took time to bring instruction. And in the meantime, they have already constructed the boundary wall, started to construct, Lordship. So at their own risk, Lordship, that order may kindly be passed. For this only, maybe listed in order column.
When?
Any date, Lordship, but we can figure it.
Okay. On Wednesday. Next.
Please,
Okay.
Your Lordship, I beg to mention RSA 148 of 2020
For what?
for orders. Orders.
Order. Why?
The matter is hearing.
Then?
No, my lord. IA has been disposed. I am the respondent here. IA has been disposed on 31st 2023, and the title execution has been stayed, which is pending before the for that reason. They are doing the appellants is doing the
You want to do the matter on Saturday? Asking you.
my lord.
How can I give importance when there are earlier matters pending? Unless there is something very important.
Take the similar one matter 149, but it is
Very good. One matter you have got it. It's good.
may allow.
If it is for hearing, I don't allow. In fact, I've asked the registry also, if by any chance the lawyer has been able to pass this court and get an order, get a listing order also, then also the registry is not going to list the matter if it is in the
My lord,
hearing. There cannot be a buy order for you.
it's my hearing for that reason. The matter is
For orders,
ordered.
orders, look,
Okay.
not for hearing.
Yes, madam. I order it.
Yes,
May I take the Lord? If with regard to item number 8, the Lord cannot like to take up. It's not very important for any other.
why? Why?
But if, because as the lawyer was the counsel for the response.
So what?
I mean,
I have been a counsel for many parties. So, can I not take it up if that matter has nothing to do? Don't make this type of matter.
in regard to item number 9, my lord, this matter has become instructed.
Mister?
Sir, A.N. Sharma on behalf of
No. Ask that person to come. I can't say that instructors. I'll look into it when the matter is.
Okay.
Here's item 1.
My lord, here I participated in my last year of month for treatment of my just I
Madam, whatever may be, I am not going to adjourn this matter. And make it very clear. What is this application? Why the matter has come? It is an SAO. SAO matters needs to be disposed of on the first day, second day. This is like a CRPIO. It can't be pending from 2012. Where is that order?
That I have come. Yeah, my
And the court has also formulated a substantial question of law in an SAO. What is that order passed?
order was passed.
Where is the order? No. First of all, is it a second appeal or a appeal against an order.
it is an order.
Then where is the question of substantial question of law? Which is the impugned order? Let me see.
Yes.
2007, 28/9/2007.
At page 31, my. Appellant was the plaintiff in the original suit, my lord.
Now tell me, under what provision is this appeal filed?
We were plaintiff, my lord, who is filed right, my lord. The suit was dictated against the order, my lord. We
You filed an application under 144.
defendant preferred appeal was allowed. Then we filed second appeal. Second appeal was this. After decision of the second appeal, they filed application under section 143, and then the order passed for restoration of position and mean profit, my lord. Against that order, my lord, we filed
Against an
appeal.
order
Yes.
passed under 144.
Yes, my lord. We
It's
filed
an
appeal.
order passed under 144.
Yes, my
Does
lord.
an appeal lie?
We filed appeal before the civil judge in your
No,
name.
understood. Does an appeal lie under 144? No. In fact, that appeal which has been filed was also honest. How do you file an appeal against that order of passing of restitution?
Yes, my lord. That appeal was allowed. That appeal was dismissed, my lord. Then and passed off. We filed objection, my lord. Filed objection.
No, madam, kindly appreciate one thing.
Yes.
You have filed an appeal against an order passed under 144.
Yes.
Does an appeal lie?
But that petition is not maintainable, my lord.
No, petition is maintainable or not, that you have to challenge it under 151, 115 or whatever may be. That is another aspect. But does an appeal lie?
Against that order, we filed CRP also, my lord. Then Honorable High Court remanded the case to the civil judge in matter for re-hearing. For re-hearing matter. This is the order. But our that petition is not maintainable. They did not file in.
No. Petition under 144 was maintainable. There's no quarrel with that. Because they have got
We did not file 144. They filed.
understood.
Yes, fine.
That petition was maintainable. There's no quarrel with that. The suit, it is a suit for right
Priority
title
right.
in interest as well as for
Yeah.
recovery of possession.
Yes.
The possession was taken over, the right title in interest was declared.
We paid for priority right. We were in possession on, and we filed an injunction petition also along with that.
Yeah.
That priority right, that it was decreed, then dismissed, then we filed appeal before the second appeal. Second appeal was this. After dismissal of the second appeal, they filed under the 144 of the
Understood, madam, but tell me, how does the appeal lie against an order passed thereby granting restitution under 144? Tell me. Don't you think the entire proceedings of filing an appeal, revision, whatever may be, in fact, you should have filed a revision there against from an order under 144. But how could you have filed all these proceedings? The appeal was totally not maintainable. A misappeal will lie under what? Where can you file an appeal? Under 144? He filed an application under 144. You filed an objection. Once you file an objection to that, the question is that the court has passed an order of restitution. Against that, does an appeal lie? Is it a decree? No. If it is not a decree, first appeal does not lie. 96 doesn't come into the picture. Is it an order in terms with 104? No. Because Order 43 does not conceive of a order in respect of 144. So the entire appeal which was filed by you is totally misconceived. Where is the question of remanding or doing anything to that effect? And can this court confer a jurisdiction upon a court which does not have? No. So the entire proceedings is misconceived. Show me one thing, only one thing from the CPC that an appeal lies against an order from 144. Show me. It does not. Matter ends there. Tomorrow, I'm just giving you an example. A court passes an order under 151. Can you file an appeal? No. The only recourse is 115. But what has happened out here? An appeal has been filed. Appellate court affirms that order insofar as the restitution is concerned, but again remands the matter back as regards the mean profit. Thereupon the court comes up, you file a revision application under 115 before this court, and this court passes an order to that effect, directing the first appellate court again to rehear and dispose it of. Now the question arises, when the appeal at all was not maintainable at the first instance, how could the appellate court exercise the jurisdiction? So the entire proceedings of the appeal is misconceived.
But in the decade, there is no order passed for mean.
Understood, madam. There is no order passed. There is no decree. Whatever may be. He has to, if he wants to go under 144 restitution, you have to challenge that proceedings in a proper forum. The appeal is not the recourse. In fact, it was not a suit filed by them.
It was our,
It was your suit,
Yes.
seeking your Aadhaar rights. The suit was decreed. You file an appeal. Appeal was allowed, and against that, your appeal.
they filed appeal against that.
No. Suit was allowed.
It was allowed.
You filed an appeal. You were a plaintiff.
I am plaintiff.
Okay.
I am
The other side filed an appeal.
Yes.
The appeal was allowed,
Yes.
thereby dismissing your suit. And then again, a second appeal was filed. The second appeal was dismissed.
Yes.
Thereby meaning where your suit has been dismissed.
Yes, my lord.
Now they file an application under 144.
But they did not pay for, did not file any counterclaim. My lord.
Understood,
Yes.
madam. Everything is understood.
Yes.
But the question arises, does an appeal lies under 144 against an order of under 144 of mean profit? Does it? No. It does not. Concept is not there. If the appeal does not lie, how are all these proceedings going on? You should have challenged that order under section 47, that order by which an application was allowed under 144 by 115 before this court directly, which was not done. It is all because of, I think, some wrong advice which has happened at that point of time of filing an appeal. These have happened. So I'll hold this, the entire appeal proceedings, all these orders are honest. However, you are at liberty, taking note of that and file an application under 115, taking into account the benefit under section 14. Because otherwise the proceedings is totally misconceived. Chalo. The instant appeal is directed against the order dated 28/9/2007, passed by the court of the civil judge Dorong at Mongoldoi in Miss Appeal number 3/2000, whereby the learned First Appellate Court confirmed the order of the learned Munsif dated 35/2000 passed in Mizze case number 20/99 and but remanded the matter back to the learned trial court to ascertain the quantum of mean profit by making an inquiry. From the materials on record, it reveals that this court had, by an order dated 26/2013, admitted the instant appeal by formulating a substantial question of law. With due respect to my learned predecessor, the said order, the said formulation of a question of substantial question of law does not arise in the proceedings of the present nature, taking into account that this appeal has been filed in terms with Order 43, Rule 1U of the Code of Civil Procedure 1908, for short, the code, read with Section 104. Formulation of a substantial question of law would only arise in a case which falls within the ambit of Section 100 of the code, which is not the case in the instant proceedings. This court, however, taking into account the order dated 26/2013, constricts itself only to the admission of the appeal and nothing further. Under such circumstances, let this court take note of as to whether, in the instant, whether any interference is required to the impugned order passed by the learned trial court, but passed by the learned first appellate court in the instant proceedings. For the said purpose, this court finds it relevant to take note of the brief facts leading to the filing of the instant appeal. Next. The appellant herein, as plaintiff, had instituted a suit being title suit number 64/1977 before the court of the Munsif number 1 for declaration that a plaintiff is an adhyar in respect to the land mentioned in the schedule to the claim, and for permanent injunction restraining the defendant from dispossessing the plaintiff from the suit land, and for certain other consequential reliefs. It is relevant to take note of that the defendants did not file any counterclaim in the said proceeding, however, contested the suit by filing a written statement. The learned trial court, by a judgment and decree dated 28/9/1989, decreed the suit in favor of the plaintiff, who are the respondents in the instant appeal proceeding. The appellants herein, who were the defendant, who were the plaintiff, the appellants, the respondent. The respondents herein, who were the defendants being aggrieved, preferred an appeal against the said judgment and decree dated 28/9/1989. The said appeal was registered and numbered as title appeal number 19/89. The learned first appellate court reversed the judgment and decree passed by the learned trial court dated 28/9/1989 by the judgment and order, by a judgment and decree dated, what is the date? Any idea?
11/7/95.
Huh?
The learned appellate court allowed the appeal on 11/7/95.
11/7/1985. 95.
Nine.
Against that, the plaintiff, the appellants herein, who were the plaintiffs, preferred an appeal before this court, which was registered and numbered as SA number 122/1995. 122,
172.
172 or 122? One 172/1995.
Yes.
The said appeal was dismissed by an order dated by the judgment and decree dated 25/2/1999. Oh, no. 25/2/1999
Yes, madam. 25.
by this court, thereby affirming the judgment and decree passed by the first appellate court of dismissal of the suit. Subsequent thereto, next, subsequent to the said judgment and decree passed by this court, an application was filed by the respondents herein, who were the defendants in the said suit, seeking restitution under section 144 of the Code of Civil Procedure, as well as also seeking mean profit. The said application was registered and numbered as Mizde case number 20/1999. The said application was duly objected to by the appellant herein on the ground that as there was no counterclaim filed by the defendants in the said suit.
And in the decree, no, there is no main profit.
Madam, I know what to write. I'm writing it. Wait, you take a seat. Had taken the ground that as there was no counterclaim filed by the defendants in the said suit, and there was also no decree for handing over of the possession, the question of filing an application under section 144 for restitution of the possession did not arise. In fact, the only remedy which was available to the defendants, who were the applicants in Ms. J case number Ms. J case number 20/99, was to file a separate suit for recovery of possession. However, the learned trial court, that is the court of the Munsif number 1,
Civil Judge Junior Division.
the civil judge trial court, that is the court of the civil judge junior division, number 1, number 2,
I don't.
number 2 or number 1.
Civil Judge Junior Division.
However, the learned trial court allowed the said application by an order dated 35/2000. without ascertaining anything as regards the what mean profit the defendant would be entitled to. Being aggrieved, an appeal was prepared by the appellants herein. Appellants, huh?
Yes.
Challenging the order dated 30/5/2000, which was registered and numbered as Miss Appeal number 3/2000. The said appeal was allowed by the learned First Appellate Court, that is the court of the civil judge Dorong, by an order dated 13/6/2001.
It is allowed. In not allowed, it was remanded.
13/6/2001. Thereby, have been partly allowed by the learned by the judgment dated 13/6/2001, thereby affirming the restitution and on the question of mean profit, the aspect was remanded back to the trial court for making fresh inquiry and passing appropriate orders. Being aggrieved, the appellant herein prepared a revision application under section 115 of the code, which was registered and numbered as CRP number 325/2001. This code, by an order dated 19/1/2005, set aside the order dated 13/6/2001 passed by the learned trial court, First Appellate Court, and directed the First Appellate Court to rehear the appeal on the entitlement of the defendant to the restitution of restoration on the basis of the application filed, and pass fresh orders in the matter together with such consequential orders on the issue of mean profit as may be called for. Being agreed, pursuant thereto, the impugned order was passed on 28/9/2007, whereby the learned First Appellate Court again partly allowed the said appeal against the order dated 30/5/2000, holding in it, thereby confirming the restitution, but remanding the matter back to the trial court for fresh inquiry in respect to the mean profit. It is against that the instant proceedings have been filed. Correct? Okay. I've heard Mr. T. Goswami, the learned counsel, appearing on behalf of the appellant. However, none appears on behalf of the respondent on call. This court finds it very pertinent to take note of that as to how an appeal at all is maintainable against an order passed in an application under section 144 of the code, inasmuch as the same by no stretch of imagination can be said to be a decree, thereby permitting filing of an appeal in terms with Section 96 of the Code, or an order falling within the ambit of Section 104 of the Code, read with Order 43. So the said order dated 35/2000, being only an order passed in an application under Section 144, in the opinion of this court, was not at all appealable. So, under such circumstances, the entire proceedings of filing the appeal, being Misappeal number 3/2000, and all other consequential orders which have been passed thereupon, is nothing but is a totally misconceived application, a misconceived is totally misconceived, and ought not to have been at all entertained at the first instance. This court, though, duly takes note of that the coordinate bench of this court had directed by the order dated 19/1/2005 in CRP number 325/2001 to rehear the appeal. But the very aspect of the matter as to whether the appeal at all was maintainable against an order passed in an application under 144 of the Code was never a question which was raised before this court. Under such circumstances, this court is of the opinion that not only the appeal, being Misappeal number 3/2000, was totally misconceived, the orders passed therein are also wholly without jurisdiction. Accordingly, this court sets aside the order dated 28/9/2007, passed by the learned First Appellate Court in Misappeal number 3/2000. The order dated 3/5/2000, passed by the civil judge, Junior Division number 1, Moholdoi, in Mizze case number 20/2099, is restored. Next. Accordingly, the instant proceedings stands disposed. Next. Before parting with the record, this court makes it clear that the order dated 35/2000, this court makes it clear. Before parting with the record, this court makes it clear that this court had interfered with the order dated 28/9/2007 on the ground that the said order was passed wholly without jurisdiction, inasmuch as an appeal did not lie against the order dated 35/2000, passed in Mizze case number 20/99. This court have not decided on the legality or validity of the order dated 35/2000 in Mizze case number 20/99. The decision herein shall not act as a bar to the appellants herein to take recourse to such other remedy as available under the law. Huh? Number 2. Where 3?
Prathame, can you see the order dated for 2018 Lordship was by the battlefield was
You are
Lordship
challenging what?
challenging the
Why
order.
both of you are challenging?
Yeah.
Both of you
Both
are
of our
against that
lordship,
order.
the matter was remanded by the learned appellate.
Yes, why both of you are both parties. One is the plaintiff, one is the defendant, whoever. Both of you are agreed by that order. That there should not have been a remand, the trial court, the first appellate court ought to have it. Isn't that your case?
But against that remand order, I also filed SAW and she has also filed a separate. Impugned order is
No, the question, additional issue which was framed, couldn't it have been decided within the purview of the evidence which was available?
Yes. All the evidence has been discussed by the learned court Peter Lordship, and on this basis, this issue could have been decided by the appellate court. And there was no need to frame the issue because it was already discussed in court by the and main point is that the court Peter has said that it is part by limitation. The suit was not part by limitation, but this issue was not discussed in the appellate order. They only go
No, no, court did not do anything.
Sir.
Has set aside.
Sir.
The setting aside is done why?
on
Very much.
on clauses.
thing that was done by
While
the
going to the impugned judgment, what is noticeable at the outset is that the learned court framed an issue on the point of limitation being numbered as 1A, but the state issue has not been discussed at all in the judgment. Rather, the point of limitation has been discussed as issue number 2, but issue number originally was in regard to cause of action, and moreover, the point of the cause of action was discussed in issue 3, but the point number 3 was in fact with having to an this effect that about in issue the right title and but this issue was in fact with regard to the sustainability. Thus, relating all this clause, the learned counsel has argued that the learned counsel was quite unmindful of the important aspect of the case that both the in fact look to the truth on the basis of you know that they right the two claim the the further case after the which is however denied by the plaintiff here on the rival seat. While the position decided the very vital issue How does the learned trial court, first appellate, can you see paragraph 18,
Paragraph
18
of judgment.
of the appellate court judgment? Was there any counterclaim?
Yes, there was a
It was allowed.
suit was dismissed and counterclaim was allowed.
You had
Lloyd-
a counterclaimant.
Yes,
No, Lord. We had a counter attack.
You had a counterclaimant. He was the plaintiff.
yes.
You claimed right title
Yes,
interest
Lord.
on the basis of
On the basis-
you are this Bhagavati Prasad Das.
Yes, yes.
You claim right title and interest.
Yes,
And that right title and interest was, they denied it in their written statement.
And that is why Lordship on the order, the earlier order dated 18/4 Lordship. They
Now, issue number 3, at paragraph number 5, duly takes care of it. Don't you?
Pardon, my lord.
Issue number 3 duly takes care of it as to whether the plaintiff have right title and interest and possession over the suit land or the defendant have right title and interest and possession of the suit land. This will duly take care as to why it is necessary for having that additional issue as to whether the father of the so-and-so inherited the suit land on so-and-so and got that same mutated in his name with the knowledge of the surviving legal heirs and with the consent of the heir. Why is it necessary? That can be very well decided in
That's why-
issue number 3.
That's why, Lordship, we approach this honorable court when the evidences are sufficient on record.
This is a complete dereliction of the duty by the first appellate court. It should have decided this way or that way. Therefore, we set aside and remand it back to the trial, direct the first appellate court to decide this.
But Lordship will be pleased to tell that this suit is pending since 2008. And all the evidences, 26 numbers of documents were exhibited. None of the exhibits show the name of the defendant as one of the owners.
I'm not going to look into
No,
that matter.
Lordship, but
But the question is, the first appellate court, let it be decided. When did you file the
18
suit?
years have already gone.
How much?
Suit is of 2008.
Mr. Roy, you don't make that statement. 18 years have gone.
Now.
Don't make
16,
that
16,
statement.
16.
So, the 2008 matter is too early. Suit is of 2008. We are only in 2024. We are yet to take up 2010
They are
second
both
appeal.
the parties are
And,
complex.
and did you see the earlier order which I passed? Entire proceedings have been going on. It's a suit of 77. The 95 matter finished. They file an application under 144. And then against that, an appeal filed.
Look, I leave you alone.
No, I'm telling you, an appeal file against that revision file. This court again directs the decision on the appeal to be again remanded again back. And then again, this court takes it as an SAO.
But your lordship, in that case, Mr. Goswami argue, why the filing section accepted the appeal? That should be the first question, lordship. Why the case was listed? Wastage of the valuable time of the court. It had not be registered as a appeal, lordship. It will only a revision under 115. So the until and unless my taken to task this.
But who is going to say, in view of the fact that the appeal has been advised by her father?
No, even then, lordship, the duty
Would,
of the
would,
registry,
would,
see,
would anybody
many-
have,
in many
and
cases
more
such things are happening.
particularly when there's an order passed by the earlier judge of this court holding that directing that appeal to be decided again. When that appeal was not at all maintainable,
Not maintainable.
they should have filed under 115 there.
Appeal cannot be filed under order 41.
That day, in fact, I got a matter of Mr. P.K. Roy Choudhury. Trial court, the first appellate court in the case of remand. That is why these SAOs are before me today. 2007, a matter has come up out there, SAO, the trial court, the first appellate court says that all these things, let the trial court decide. Remanded. Everything is there. What is there to remand? And from 14, 17 years have gone in this court on that ethic. And the SAOs are now being treated with par with an RSA. And if it is being treated with a par with an RSA, it gets therefore stagnated. So therefore, I have asked the registry to get all these SAOs listed because SAOs are more like a CRPIO.
Yes.
These are impeding on either the appeal is to be decided or the trial court has to decide. You can't, it is on a very short question. Nothing is much to be looked into. Chalo, lekho. The instant appeal, now both the appeals are taken up together, taking into account that both the appeal arises out of an order dated 18/5/2013 passed in title appeal number 32/2011. Whereby the learned first appellate court, that is the court of the civil judge Dibrugarh, had remanded the suit back to the learned trial court in exercise of the powers under Order 41 Rule 23A by formulating an additional issue thereby giving due opportunity to both the parties to adduce evidence. The question therefore arises before this court is as to whether the learned first appellate court has shirked its responsibility in deciding the appeal, and the order so passed is in violation, is contrary to the provisions of Order 41 Rule 24 of the Code. I've heard you, whose first appeal is this? Your number is? That I know. Who is number 2? SAO2 is yours? Okay. I've heard Mr. S.P. Roy, the learned counsel, appearing on behalf of the appellant in SAO 2/2013 or 14? 2014. Oh, no, he's in later. I've heard Ms. K.D.B. RDB appearing on behalf of the appellant in SAO number 6/2013 and Mr. S.P. Roy, the appellant in SAO number 2/2014. The said counsels also duly represents the said their appellants who are the respondents in the
My lordship,
respective appeal.
lordship, my SOE is 2/13.
Yours is 2/13.
Yes.
No. Some orders, all the order sheet, it is written as 2/14.
I filed on 30th of August 30th.
Wait. Huh? 14 में 13. 14 ही रखा है.
Oh, sorry, my
14.
sorry, my
14.
it will be subsequently it was corrected.
14.
Sorry.
Who appears for the respective respondents in those appeals. The brief facts leading to the filing of these appeals are that the appellants in SAO number 2/2014 as a plaintiffs had instituted a suit
Yes, number 10 of 2008.
being title suit number 10/2008
Court of the London Munsim number 1.
seeking declaration of their right in the plain anywhere. Seeking declaration
Plain 10, page 10.
seeking declaration
Prayer for
that they have got right title and interest over the suit land, being the absolute owner and in possession for the last 5 decades. Semicolon, for declaration that the order dated 9/12/1969 passed by the SDC Dibrugarh East Circle, Dibrugarh, in mutation case number 42/1969-70, mutating the name of late Bhagavati Prasad Das in respect to the suit land to be void, illegal, and inoperative in law, and deletion of the name of the defendants and their mother from any records available in the office of the Deputy Commissioner, Dibrugarh. For declaration that the order dated 11/9/1970 passed by the learned additional Deputy Commissioner, Dibrugarh, in mutation case number 37/1969-70, and also giving separate patta being PP number 71 in favor of late Bhagavati Prasad Das is void, illegal, and inoperative in law, and deletion of the name of his heirs from any records available in the office of the Deputy Commissioner, Dibrugarh. For declaration that the order dated 19/9/97 passed by the SDC Dibrugarh West Revenue Circle in MC case number 87/1997, granting mutation of the name of the defendants and their mother is void, illegal, and inoperative, semicolon. For declaration that the notice of demarcation issued by the Circle Officer, Dibrugarh East/West Circle in demarcation case number DEC/D/54/2004-5 to the plaintiff number 1 is void, illegal, and inoperative in law and not binding, and for perpetual injunction restraining the defendants from trespassing over any portion of the suit land and from disturbing the peaceful possession and enjoyment of the suit land by the plaintiffs. The defendants jointly filed a written statement cum counterclaim denying the case of the plaintiffs and further claiming the declaration that the defendants have got right title and interest over the land measuring 0 bigha 2 katha 4 lechas of periodic patta number 71 covered by dag number 94 of Tinkunia ward of Dibrugarh Moza, district Dibrugarh, semicolon, for khas possession of the suit land as described in the schedule of the written statement cum counterclaim by evicting the plaintiffs, their men, women, representatives, etc. For semicolon, for permanent injunction restraining the plaintiff and their workmen of their men, women, workers, representatives from making any alteration, repairing, renovations, new constructions over the suit land, and from making any deed of conveyance involving the suit land and premises, and from doing any act prejudicial to the nature, etc. On the basis of the claims suit filed by the plaintiffs as well as the written statement cum counterclaim filed by the defendants, the learned trial court framed as many as 7 issues, which being relevant for the purpose of the adjudication of the instant appeals are reproduced hereunder. Page 80 পাবতে এটা আছে 1A বুলি দিয়া আছে 1A 2 3 4 5 6 On the basis of the evidence which have been duly tendered by both the plaintiff as well as the defendants before the learned trial court, the suit was dismissed and the counterclaim was decreed by the judgment and decree dated 24/6/2011 by the learned trial court in title suit number 10/2008. By the suit being title suit number was decreed in favor was disposed of by a judgment and decree dated 24/6/2011 by dismissing the suit of the plaintiffs and decreeing the counterclaim of the defendants. Being aggrieved, the plaintiffs preferred an appeal being title appeal number 32/2011. The learned first appellate court, by the impugned order dated 18/5/2013, remanded the suit back to the learned trial court by framing an additional issue. And it is under such circumstances the instant proceedings have been, both the proceedings have been instituted. This court have duly perused the records which are available, which were duly called for. And from the records, the evidence have also been duly taken note of. This court have also taken note of that the issue number 3 categorically dealt with the issue as to whether the plaintiffs have right, title, interest, and possession over the suit land, or the defendants have right, title, and interest and possession over the suit land. Under such circumstances, this court finds it very difficult to under such circumstances, this court is of the opinion that the framing of an additional issue as to whether the father of the defendant, namely late Bhagavati Prasad Das, inherited the suit land in 1969-70 and got the same mutated in his name with the knowledge of all surviving heirs with the consent of his mother, Akani Bala Das, was not at all necessary, inasmuch as the issue number 3 would duly take note of, would duly take care of such additional issue. Further to that, this court, having taken note of the evidence on record, is of the opinion that the learned first appellate court duly had the evidence on the basis of which the learned first appellate court could have decided the appeal, rather than remanding the appeal back to the trial court by framing an additional issue. This aspect, it is the further, the said order, in the opinion of this court, is therefore totally contrary to the provisions of Order 41, Rule 24 of the Code, for which this court sets aside the appeal, the order dated, impugned order dated 18/5/2013, passed in title appeal number 32/2011, and further directs the learned first appellate court, that is the court of the civil judge Dibrugarh, to decide the appeal on its own merits, appeal on the basis of the evidence available on record, on the basis of the materials available on record, Full stop. Taking into account that both parties are duly represented, this court fixes the matter before the learned First Appellate Court, that is the Court of the Civil Judge Dibrugarh, on 1st of July 2024, on which date both the parties shall appear and the learned First Appellate Court shall thereupon decide the said appeal in accordance with law,
Time may be
without being influenced by the observations made in the instant proceeding, in the instant order, as well as the order dated 18/5/2013, passed by the First Appellate Court, impugned in the instant proceedings. This court have also taken note of that already 2008 suit,
in law.
already 16 years have passed by. And as such, this court requests the First Appellate Court, that is the Court of the Civil Judge Dibrugarh, to take appropriate steps to arrange the business of its court in such a manner that this appeal can be disposed of within 6 months from the date of appearance of both the parties.
Obliged.
The registry shall forthwith take appropriate steps for transmitting the records back to the learned First Appellate Court, that is the Court of the Civil Judge Dibrugarh, and if need be, take recourse to the special measure.
Lordship, I had one prayer. I am having item number 10. My chamber is going under renovation. I
Right.
could not locate my file. So it will be
Not necessary. We'll see when you have that file. By the 10 we reach, you can assist me. Don't worry. These matters are not to be adjourned, and this thing I informed it last Friday. Last Friday, it was notice was given that these matters no exist now.
Support.
Yes, what is this FAO?
Okay, this is an appeal against an order by which a succession certificate was.
Huh?
Succession
Succession certificate was granted.
was granted.
I want to view the opposed party.
Succession certificate.
So what is wrong with the order?
In respect of the movable properties of one Sri Ajit Chandra Das, he
Uh.
died on 9/2/2013, leaving behind his wife and a daughter.
Hmm.
After the death of the deceased Ajit Chandra Das, the daughter also died.
Hmm.
And on that date, your lordship, the daughter was already divorced and he had a minor son.
Hmm.
The son was residing with his father,
Hmm.
the husband of the deceased daughter.
Wait. First and foremost, let me see. Who is respondent?
Respondent here,
Appellant is Master Debosri Sanda. Who is he?
he is the son of the daughter of Ajit Chandra Das, whose property regarding.
You were a party there.
Yes, I was made a party.
You had a grandson.
I'm the grandson.
You got 1 lakh.
50% of that.
So did you get 1 lakh
1 lakh was granted by the court.
to you?
Yes.
Then
Then
what do you want?
50% of the property.
Why?
Because as per law, your lordship, if I can prove that he is entitled to 50% of the property of the.
How?
Ajit Chandra Das, your lordship,
Hmm.
he died on 9/2/2013.
Where? Ranjan Das
Ajit Ranjan Das. Ajit
died on
9/2/2013.
9/2.
9/2/2013.
Yes, then
Leaving behind Tripti Das and Snigdha Das.
leaving behind
Tripti Das,
Tripti
the
Das,
widow,
a wife,
the wife,
Tripti Das,
and Snigdha Das.
the daughter.
Stignara.
So as on the date of death, your lordship, as per section 8 of Hindu Succession Act,
Hmm.
the property would devolve 50-50 upon the
50-50, yeah.
daughter and the wife.
Hmm.
Thereafter, the daughter died.
Okay.
Daughter died on 7/3/2013.
7/3/2013. 1 month.
After one, within one.
Deep sorrow. Yes. Then
Then he was, there was a minor son, Devotita, who is the petitioner. So the 50% property that devolved upon Snigdha, the daughter, will be distributed as per section 14 of
and
the
how does the trial court decide?
trial court decides that both of them are entitled to 50-50.
Then
However, taking into consideration that the widow is that the minor is staying with the father, out of sympathy, 1 lakh is to be given to him and 50%.
now where is that order?
It is
Herein
page
is
eight,
the
page
son
eight,
of the
your lordship.
predeceased son. So as per class 1 here, it appears that Obey is the class 1 event as the petitioner is a legally married wife. And class 1 heir of here, there is no impediment in issuing the succession in favor of the petitioner. Let the succession be issued in the name of the petitioner in respect to the debts and securities left by it. He is also a class 1 legal heir to the entitled equal shares of the debts and even not can be taken below, except the amount left by considering on the how much is the succession certificate asked for?
5,07,340.
And this petition is being filed at whose instance?
The minor.
The minor has the money. So why is it required for the minor to
Represented by the father.
there? Right.
Now he is major.
So the father wants it. No going to
As
go to-
on date, your lordship,
better you go to Supreme Court.
as,
Spend money.
as on
Absolutely no. The reason is, and what happened? Nothing is remains. This is the appeal of 2015. 9 years have gone by.
there's an IA, your lordship.
There's a stay.
They are in regard to 50%. 50% was allowed to be given to the
Then?
widow.
And where is the mother?
Can you inform the council? I can inform
Who is it?
PK Debroy. PK Debroy.
PK
Debroy.
Dave Roy. Where is he? Why is he not appearing? And what is your age now?
21.
Huh?
23 years.
Then what remains here? Get the money. You are now want to take away the money from your grandmother? Shame on your face. After the husband left her alone and you are now under the help of the father is there, now you are major out there. Don't you have the little bit of shame out there?
I understand.
Forget about law. There is a bit of basic decency. If I was in your place, I would have been more, what do you call, perturbed by to make that submission out there. You are now 23. Earn your money. Won the money of the year. Yes, you are entitled to the share as regards the immovable properties. That's okay. But what is there with the money? Why should this court interfere? And that too after 2015. No. And what is the age of your grandmother? Huh? Tell me. You want the property of your grandfather, but you don't know. Have you visited her? Very sad. Hello, let me. My conscience does not permit it. Let me come back and dismiss it. You just think about how much cost on you.
age of the grandmother, can I ask for 5 minutes time, Your Lordship? I'll just take an instruction if I forgo my claim and
I think you should withdraw.
I'll just take my
You take a call.
consent.
This is not a case for
I understand.
interference. Interference to not necessarily. You shouldn't have at all filed this appeal. We'll have it up to some time.
Hey, please, my lord, this matter has become infectious.
Hmm?
This matter has become infectious. My lord, this is against the order of refusal to grant injunction, my lord. And in the meantime, suit is already disposed of, my lord. This is the order.
The instant appeal is directed against the order dated 16/9/2015, passed in Mizze case number 70/2015, arising out of title suit number 49/2015. Mr. A.K. Gupta, the learned counsel appearing on behalf of the respondent, submits that in the meantime, the suits so filed have already been dismissed by the judgment and decree dated 23/2/2018, and the counterclaim filed by the respondent, where the respondent was decreed. Taking into account that the suit have already been disposed of, nothing further remains in the instant proceeding, for which the instant appeal stands dismissed as it has become infructuous. Yes,
This case, Lordship, I am the evidence. My suit was partly decreed and thereafter they filed an appeal, Lordship. The first appellate court held that an additional issue may be cited against that whether I am the owner of the suit or my daughter is also owner for non-gender issues. So remanded the suit for retrial and against that, page 104, para 12 is the remand order.
who filed the plain suit?
Lordship.
You filed the suit.
Yes.
Claiming what?
Claiming that, Lordship, I am the owner of the suit land. I have handed over some documents to defendant number 1. He being an advocate for conversion of my annual patta land to Nyadi patta land. Lordship. Taking the benefit of Lordship ignorance of legal procedure, Lordship, he has recorded his name in Chitta, showing that I have put my signature in the Chitta, allowing him to be the recorded patta. So on those allegations, Lordship, I have filed the suit. Lordship. And dependent number 1 case is that, Lordship, I have sold out the suit land by that unregistered deed in his name. Lordship. So, Lordship, he is
I then unregistered deed.
yes, Lordship.
Then
So, Lordship, he is admitting that I am the owner of the suit land, Lordship. But
an
Lordship,
unregistered deed.
yes,
Value is less than 100.
no, Lordship, more than 1. That is also a ground in my essay, Lordship.
Then
Then first appellate court held that, Lordship, 1 Rupali Kuwar in
what did the trial court do?
trial court partly dictate, Lordship.
Why? Your name is Toktel Lakam.
Yes, Lordship.
And who is the advocate? Bhupen Pegu.
Bhupen Pegu, Lordship. Page 74, trial court order, Lordship. The suit is decreed partly with cause. The plaintiff is entitled to the degree of declaration of right, title, and possession in the suit land. Permanent prohibitory injunction restraining the defendant number 1 and all his agents, dependents, and workers from entering into the suit land. And some other prayers are also there for recording, deleting the name of the defendant number 1 from record of rights. Lordship. Those were not. And thereafter, Lordship, they filed title appeal. They have not taken any ground that Rupali Kaur is also a owner of the suit. But first appellate court held that he is also a owner of the suit, so non-gender is decided. Para
Now,
12
did
here.
they take that ground in the written statement?
No, Lord. Written statement, Rupali Kaur's name was there. Only an allegation that Rupali Kaur alleged that she is the owner of the suit land. So, Lordship, he filed a criminal case that was dismissed against the defendant number one. That is only by the name of the Rupali Kaur was mentioned, but he did not admit that Rupali Kaur is also a owner. Lordship. Page 17, para 5. Here.
Did Rupali Kaur anywhere came out there? No.
No,
He
she
is
filed
your
a criminal.
daughter.
She filed a criminal case as per written statement against the defendant number one. That was
Who is Rupali Kaur?
she is my husband's second wife's daughter.
And this property is was in your name.
Earlier in my husband's name, then I am the owner of the property. And he already admitted that Lordship he has taken.
Where is the statement as regards non-gender of party in the written statement?
That was not in the written statement, Lordship. There was no such statement taken by the defendant. The suit is bad for Lordship non-gender of the party. There was no such statement, and Lordship maintainability of the suit was also decided by the trial court. Page 58 is the maintainability of the suit in its present form. Both the above stated issues are decided in favor of the plaintiff, and there is no any reason from the defendant side as well as from the perusal of records why and how the present suit is not maintainable in its present form. Maintainability of a civil suit is to be determined on the basis of pleadings of the parties. Maintainability does not depend upon the evidence of the parties, hence the suit is maintainable in its present form. And even no non-gender issue was formulated by the trial court during trial. They did not raise any objection in regard to that. Only the issue number 3 is that whether the plaintiff has got right-sided interest over the suit.
Now kindly come to page 104, paragraph 11.
The Thane trial court thereafter passed the appeal judgment in favor of the respondent. However, before going to the nitty-gritties of the appeal judgment, what catches the eye of this is that the fact that it has been averred by the respondent that she had acquired the disputed land in by way of inheritance from her husband, late Pavitra Kaur, and the evidence had made a specific averment that there was other legal heirs of the late Pavitra this purpose.
Now this, where is that averment?
In the written statement.
Yes.
Where is the
Written statement at page number 17, Lordship.
page number?
17. 17. Paragraph number 5.
That is not a statement to that effect. That statement also says that there is another daughter of the second wife and she has filed an objection.
Yes.
There is no objection to that effect that there is a non-joinder of party.
That specifically is not.
Why it was remanded? No. This is an application. This appeal. The instant appeal is an appeal under Order 43, Rule 1U, read with Section 104 of the Code of Civil Procedure 1908, challenging the order dated 21/2/2017, passed by the learned District Judge Dhemaji, whereby the learned District Judge had remanded the suit back to the learned trial court by framing an additional issue as to whether the suit was bad for non-joinder of necessary parties. It is relevant to take note of that in the written statement that the plaintiff had filed the suit seeking right title and interest over the suit land. As well as also declaration in respect to certain orders and entries being made by the respondent authorities in respect to the suit land in favor of the defendant number 1 and for permanent injunction. The entire cause of action of the suit was primarily against the defendant number 1 on the ground that the defendant number 1 by executing fraud had claimed title over the suit land. And thereupon had tried to take over the possession over the suit land from the plaintiff. The defendant number 1 had filed a written statement without alleging that the suit was bad for non-joinder of necessary parties or for proper parties. Only a statement was made in paragraph number 5 that one Rupali Kaur was the stepdaughter of the plaintiff who had filed an application against the defendant number 1 before the SDO. The learned trial court, by the judgment and decree dated 4/9/2015, in title suit number 4/2012, decreed the suit in favor of the plaintiff to the extent of declaring the right title and interest of the plaintiff over the suit land, as well as also granting a permanent injunction. However, the declaration so sought for, insofar as the entries so made by the respondent authorities were not specifically decreed in favor of the plaintiff. Be that as it may, the defendant filed an appeal. Defendant number 1, who is the respondent number 1 herein, had filed an appeal before the court of the district judge, Hemaji, which was registered and numbered as title appeal number 4/2015. The learned First Appellate Court remanded the said suit back to the trial court for deciding afresh by framing an additional issue as to whether the suit was bad for non-joinder of necessary and proper parties. And it is against the said the instant appeal has been preferred. This court, while an order dated
Right, court.
25/4/2017 had admitted the appeal by formulating two substantial questions of law and had also directed the appeal to be registered in terms with Order 43 Rule 1U of the Code. At this stage, with due respect to this court, at this stage, with due respect to the coordinate bench of this court, the question of formulating a substantial questions of law in an appeal arising under the appeal filed under section 104, read with order 43 of the code, is totally foreign. Be that as it may, this court limits its adjudication. This court constricts itself to constricts the order dated 25/4/2017 as an admission of the instant appeal. I've heard the learned counsel, Ms. R. Chaudhary, appearing on behalf of the appellant, and Mr. S. Deka and T. Chaudhary appearing on behalf of the respondent, number 1, Mr. R. T.K. Bhuya appearing on behalf of respondent numbers 2, 3, and 4, and have duly given anxious consideration to their respective submissions. This court, upon perusal of the impugned order passed by the learned First Appellate Court, finds it strange to observe, finds it relevant to observe that when there was no objection taken in the written statement, that there was another legal error. And there was no objection taken in the written statement that the suit was bad for non-joinder of necessary parties, or for that matter, that the suit cannot be proceeded without Ms. Rupali Kaur being arrayed as a party in the suit. How did the learned First Appellate Court arrive at the finding in paragraph number 11 of the impugned judgment that there are specific averments that there was other legal heirs of late Pabitra Kaur? Besides that, it is also relevant to take note of that the cause of action in the instant suit pertained to a fraud being committed by the defendant number 1, who had claimed the right over the suit property on the suit property, and also the various and seeking a permanent injunction against the defendant number one. Even a co-owner can maintain a suit in that regard. This court, further taking into account, this court have also perused the materials on record. And finds that there was evidence which was available. There were material, the evidence were duly available before the learned first appellate court to decide the appeal in accordance with the mandate of section 96 of the code. Accordingly, however, the learned first appellate court acted contrary to the provision of Order 41, Rule 24 of the court and remanded the suit back to the learned trial court. That too, on an issue which was not at all necessary for the purpose of deciding the said appeal, suit, which was not at all necessary in respect in deciding the said suit. Accordingly, this court sets aside the impugned order dated 21/2/2017 passed by the learned district judge Dhemaji in title appeal number 04/2015 and direct the learned first appellate court, that is the court of the district judge Dhemaji, to decide the said appeal on the basis of the evidence which are already on the basis of the materials which are already available on record. This court also finds it relevant to take note of that the suit was filed in the year 2012 and almost 12 years have passed by, and as such, this court requests the learned district judge Dhemaji, which is the first appellate court, to decide the said appeal within a time frame and preferably within 6 months from the date of the appearance of the parties. Taking into account that both the parties are duly represented, the parties are represented before this court, the parties are directed to appear before the learned first appellate court on 1st of July 2024 for further proceedings of the appeal. The registry is directed to forthwith transmit the records to the first appellate court, that is the court of the district judge Dhemaji, and if need be, take the help of a special messenger so that on the next date so fixed, the records are received by the learned first appellate court. Yes. What is this FAO business?
After hearing this case, but the order dated 17/1/2017. This
Huh?
is page 17/1/2017 law, page number 55. The miss case which was filed under order 41 rule 21, that was rejected. Suit was filed by the petitioner hearing this appellant. Accordingly, suit was decreed and the appeal was preferred. The appeal was preferred and by the state, and that was an ex parte judgment and decree. So after coming to know about the ex parte judgment and decree, there was substantial delay with regard to the fact. The application was filed under order 41 rule 21, and that was summarily rejected. Now the rejection order, if you kindly see at page number 55, the point that was raised by the appellant hearing was with regard to the fact that when the appeal was preferred by the state, no notice was served upon the appellant. So that aspect of the matter was not properly taken care of by the Learned Lower Appellate Court by rejecting the appeal.
Then
That was, so I preferred an appeal under order 43, challenging that particular order dated 17/1/2000. Immediate structure of this particular matter. It was with regard to declaration of right title interest, information of possession, and the land ceiling, that was the order which was passed in the land ceiling case.
now why in your application certain other aspects are being looked into? Your own application was only to the effect that you wanted a rehearing on merits,
Exactly.
taking into account that the appeal was disposed of without hearing it.
Without,
Isn't that your
Yes.
case? If that be so, you must have assigned some reasons.
Yes.
What was your reason?
reason means lordship is not.
What is your application? Where is your application?
I have not annexed the application.
We dismiss it on that.
Lordship is,
Record size.
the record is there now.
If the
Because
record.
only limited player, it is there. in the
No,
order
don't
itself.
come up with this limited player.
Because in
Limited
the order
players
itself
are
it is
already
reflected.
there.
So
No,
there was
no,
delay.
no.
And
Sorry.
because of that delay, there is no explanation with regard to the delay. And the
I'm
point
not
that
on those. Where is your application? How have you filed that? There must be good reason why you have filed that application.
was when the certified copy
This
was,
case number 8,
yes, Lord.
you filed.
Yes.
There is the petition. Yes, Mr. K. Bhutchach. What case
My
you
lord,
have?
this case was filed after, 18 years. After this title appeal, judgment was passed. That is on page 39. And in that judgment, it was found that the gift deed was found to be illegal, my lord.
I'm not on that.
Oh.
We are least bothered with all if
Yes. So in any case, they should have filed a condonation of delay petition before filing this case.
Where?
That they filed after 18 years, the court should first allow the delay of 18 years. Then only it can hear it, my lord. And in any case, it has been dismissed. So on every point, it is wrong, my lord, the procedure, my lord. I mean, the condonation petition was not filed at that time, at any time, at that stage. So how did the court consider this petition? And then,
How does the court deal with this order?
so that is the problem, no?
Let's
my
see the
lord.
impugned order.
Also, it is the
After
page
18
number-
years, my.
Page number 55.
Huh?
Page number 55. of the
And
memo of
if
appeal.
there may have been a condonation petition, but they have not been able to show it till now. That is what. There may have been.
Yeah,
I'm not saying.
Mr. S.P. Chaudhary indulges in not.
So my lord will find it in the record, my lord, if the
I've seen the
condonation petition was there at that time.
Where is that order? Impugned order is where?
Page number 55, Lord.
Huh?
Page number 55, annexure 7. The operative portion started from page number 50.
You didn't file section 5.
That application was not there, but in the petition itself, order 41 rule 21, the application which was filed. In that petition, the explanation was given. Basically, from the date of knowledge, because the knowledge came to know from when the petitioner, the appellant had.
But don't you see, how do you take care of the substantive right?
Yes.
Under section 3 of the limitation? That can only be taken care of by 5. Without 5, how can you take care of?
Here in this case, not this explanation, which is otherwise required, the delay in preparing that.
How do I convert the order 41 rule 921 application to be an application under section 5 as well? If I cannot, because the power has to be there by condoning the delay. There are two aspects. Order 41 rule 21 application is only in respect of rehearing why you could not appear on that day. Okay. But if I convert it that also or make it also an application under section 5, taking into account that you had no knowledge about it, how do you deal with that aspect? How can you, this court, do that?
Because lordship in this, for this particular provision out of 14 rule 21, this is with regard to the service of
Understood, everything,
not served.
understood.
So
Just
that
for
particular
example,
aspect was taken
no,
into
let us take the example of Order 9, Rule 13.
Yes.
Can you just, after 10 years, file an application under Order 9, Rule 13? Can you? Without a limitation. We have not done, you can't help it. How do I do it? How do I convert it? Tell me. This will be going directly against Section 3.
Yes.
I can't help you with it.
Now, the only point before this Honorable Court is that the issue that was raised in this application was knowledge, the date of knowledge. If
Understood.
date of knowledge is to be taken into account, then there was no such delay. Presumably, for that reason, the application was not filed.
Is 123 stating
Yes.
about date of knowledge?
No.
From the date of the order.
Yes.
So how do we take care of?
Otherwise, lordship permits, then fresh application may be filed. Then explanation is that admittedly it was not served. Since the application was pending, and file an application for setting aside, then application for continuation.
My lord will have to decide whether this court, the day, what the order dated 7/1/17, could this court have heard that application without confirming the thing? That, my lord. And if it can't, this order has to go. Because it can't even hear it, so how can the order stand? So that is the main. And now, as on today, 26 years has passed from the date of the title appeal order, the judgment. 26 years.
But you see, kindly see page 59.
59.
What was the decree you got?
Decree with regard to declaration of my right interest
And
and confirmation of possession. Decree is there, lordship, at page number 25.
and what? Only confirmation
The
of possession.
orders and the orders in land ceiling case number such and such is not binding upon the plaintiff because of the gift deed. Because that particular land prior to land ceiling, that was gifted by the original owner, by the father of the applicant.
Then what?
So the for declaration of a right title interest and in respect of land described in the schedule 1 below, for confirmation of possession, for further declaration that the orders of land ceiling case number such and such is not binding upon the plaintiff in respect of the land described in schedule 1 and for a permanent.
Now,
Yes.
in view of that order,
Yes.
whether it was brought outside the land ceiling, it has to be shown somewhere. There is already an order. It's not binding, you are asking. Has anything happened there? Because you got a decree in 2019-95.
90,
19?
96.
96.
90.
So, was anything done by the respondent?
That was not.
Huh?
That was not.
So if that is not there, they must have taken action. It is now shown as government land or what? They must have shown it as government land.
That is the matter.
Have you paid the khazna?
That is the matter. That is
No,
Yes.
these aspects needs to have been mentioned. Because how did you come up and say, after 18 years, you go to the trial court and say that, look here, give me those documents. Why? Why after 18 years?
No, that
Without any-
explanation is there in the plaint itself.
That is what I'm saying. Why after 18 years? There has to be some reasonability. You don't go to a court out there. 96 is the judgment. 2015, you worked up. Let me get those documents. Why? There must be some good reason. Why did you go after 18, 19 years? There's no explanation to that.
Explanation to that extent.
No, and then how do you help it?
Only the factual aspect is that lost. If notice was never been stamped upon the appellant. So that issue was raised before the learned.
Notice was served, that has been shown, and there is an order to that effect. Now, whether it has been rightly served or not, how can the court decide without the section 5? One. Secondly, where is the question? Why? Where is the explanation? There's no explanation. And the trial court is right. Even if we remand it, I can't touch this order. The order is very clear that I am of the opinion that merely by approaching the court and stating that we had knowledge about the matter on a particular date, which was after abnormally long period, cannot be sufficient in order to render. In fact, the court did not go much into the section 5 also. Rightly done. If there's no explanation, why one fine morning in 2005 you want to go? Chalo, lekho. This is an appeal under order.
And my lord, one more thing in the
They
gateway
don't
explanation.
mention anything. Take your seat. I'm passing the order in your favor. This is an appeal under order 43, rule 1T. Of the Code of read with section 104 of the Code of Civil Procedure, challenging the order dated 17/1/2017 passed by the learned Additional District Judge Kachar at Silchar in Mizze case number 8/2015, arising out of title appeal number 9/2016, wherein the application so filed by the appellant herein was rejected. It appears from the records that a suit was filed by the plaintiff, by the appellant herein, before the court of the Additional Assistant District Judge number 1, Silchar, as it then was. Being title suit number 68/1991, seeking declaration of her right, title, and interest in respect to the land described in Schedule 1 below, in the Schedule 1 to the plaintiff, and for confirmation of possession. In addition to that, the appellant had also sought for declaration that the orders in sealing case numbers 2/1971-72 of the Court of the Collector, Kachar Silchar, land sealing branch, is not binding upon my client, upon the plaintiff, in respect to the land described in Schedule 1 or the Schedule 2 to the plaintiff, and for permanent injunction restraining the defendant from taking over the possession of the land described in the schedules below, or from disturbing the peaceful possession of the plaintiff or allotting the same to any other person. The suit was duly contested by the defendant by filing written statement. The learned trial court, by the judgment and decree dated
29 to 99. Case number
29/2/1996, decreed the suit in favor of the plaintiff, that is the appellant herein, thereby declaring the plaintiff's right, title, and interest in respect to the suit land, and also confirming the possession of the suit land in favor of the plaintiff. Further to that, the respondent herein, who were the defendants, were permanently restrained from taking over the possession of the suit land from the plaintiff, with the force of any order passed by the in the land sealing proceedings. Against the said judgment and decree dated 29/2/1996, an appeal was prepared by the defendants who were by the respondents, which was registered and numbered as title appeal number 9/1996. This court duly takes note of that the service upon they duly takes note of that on duly takes note of from the records that on 15/9/1998, the learned First Appellate Court, taking into account that the notice to the last residence of the respondent have been returned after service, fixed 31/10/1998 for necessary order. Thereupon, on 31/10/1998, as the respondent was absent, the appeal was directed to proceed ex parte. Subsequent thereto, the appeal was allowed by a judgment and order dated 15/3, judgment and decree dated 15/3/1999. Thereby, setting aside the judgment and decree passed by the learned trial court. After 16 years thereafter, the appellant visited the presence of the learned trial court to get back the original documents which were submitted during the trial of the suit, being title suit number 68/1991, and came to learn on 8/5/2015 that an appeal was filed against the judgment and decree dated 29/2/1996, passed in title suit number 68/91, thereby and taking and the said appeal, which was registered as title appeal number 9/96, was decreed in favor of the appellant the defendants in the suit. It is under such circumstances an application was filed under Order 41, Rule 21 of the Code, challenging for rehearing of the appeal on the ground that the appeal was heard without affecting due notice upon the appellant hearing. The said application, however, was not. The said application, however, in the said while filing the said application, no application was filed under Section 5 of the Limitation Act seeking condonation of delay. The learned First Appellate Court, that is by the order dated 17/1/2017, the application filed under Order 41, Rule 21 of the Code was registered and numbered as case number 8/15. The learned First Appellate Court, by the order dated 17/1/2017, dismissed the said application, holding inter alia that merely by approaching the court and stating that the petitioner had knowledge about the matter on a particular date, that is on 8/5/2015, which is after an abnormally long period, without proper explanation and without supporting documents, cannot be sufficient in order to render the contentions of the petitioner acceptable, and thus as such, the said application was held to be devoid of sufficient merit, for which the same was dismissed. It is against the said order dated 17/1/2017, passed in Ms. case number 85 of 8/2015. The present appeal has been filed. I've heard Mr. S.P. Chaudhary, the learned counsel, appearing on behalf of the petitioner appellant, and Mr. K.K. Bhattacharjee, the learned counsel, appearing on behalf of the respondents, and have given due consideration to the respective submissions. This court have also perused the application under Order 41, Rule 21 of the court, filed by the appellant before the learned first appellate court. This court have also perused the records of Ms. case number 8/2015, and therefore nothing is available. And therefore it would be seen that the application so filed under Order 41, Rule 21, therefore it would be seen that no application was filed under Section 5 of the Limitation Act 1963 for condoning the delay in preparing the application under Order 41, Rule 21 of the Code. This Code further takes note of Section 3 of the Limitation Act 1963. And in the recent judgment of the Supreme Court in the case of reported in so and so, the Supreme Court had made it very clear that the provision of Section 3 of the Limitation Act 1963 is required to be construed strictly. Though Section 5 of the Limitation Act could be has to be liberally construed. The Supreme Court further in the said judgment made it clear that rights accrue on the basis of Section 3 of the Limitation Act, and since any sufficient cause being shown by filing due application, the question of condoning the delay does not arise. In terms with Article 123 of the Limitation Act, of the first of the schedule to the Limitation Act 1963, it has been stipulated that for filing an application under Order 41, Rule 21, the period of limitation is 30 days from the date of passing of the order. Under such circumstances, by virtue of Section 3 of the Limitation Act, the application under Order 41, Rule 21 was barred by limitation and could not at all have been entertained by the learned could not at all have been taken into account by the learned first appellate court. This court also finds it very relevant to take note of. No. In addition to that, this court also finds it very pertinent to observe that in the application so filed under Order 41, Rule 21, which have been registered as Ms. case number 8/2015, and the contents of which this court have duly perused, There is no explanation why after 16 years from the date of the judgment passed by the learned trial court on 29/2/1999, the appellant went to the precincts of the learned trial court to get the documents which were exhibited and not any time prior thereto. This categorically shows that it is now categorically shows that the explanations were given, even if construed liberally, does not appear to be bona fide. The learned first appellate court duly have taken note of the said aspect of the matter in the impugned order dated 17/1/2017. And as such, this court finds no reason to interfere with the same. Accordingly, the instant appeal stands dismissed. The records, the registry cell forthwith return the records to the courts below. I've recorded everything what you wanted to say.
Yes.
Yes.
One small thing, but very complicated.
Very. Yes, withdrawing. Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the appellant, submits that he would not, that the appellant would not like to press the instant appeal, taking into account the taking into account the above, the instant appeal stands dismissed on withdrawal. Interim orders which have been passed in the interlocutory application stands vacated. The order dated 16/4/2015 in meet S bracket S bracket close 19/2014 shall hold the field.
One thing,
LCRB.
this may not prejudice the other cases that are there.
Be that as it may, it is however mentioned that the instant appeal being a proceedings only limited to the succession of the debts and liability. What is that? The word used?
Debts and security.
Debts and security. The same. The decision so made in the impugned order shall not affect the rights of the appellant in respect to other immovable properties left behind by late Ajit Ranjan Das. Yes, tell me.
Lordship, the petitioner as plaintiff instituted a suit 1/2012 against the defendants for damages and compensations, along with a mistake Estama injunction petition of 3/2013, wherein by initial order 8/2/2013 granted interim injunction, extending the defendants, mainly defendant 1 and 2, not to delete the links. Not to delete the links. So that is what contents of the links. That means what was aired on that particular day. Not to.
Then?
Thereafter, that order was made final by 10/4/2013. Suit was proceeding. There is another parallel CRP is also going on before this honorable court. CRP 291/2017. Paying for filed by the respondent number 1 and 2. Paying for.
What is the stage of the suit?
Suit, it was PW1 was already prosecuted. All PW evidence is already over.
Then what do you want now?
Problem is that this is the primary evidence. D and E. we could not go to the site because of delinking that person,
Then what
Hyperlink
did you
was
ask
removed.
for? Did you get an injunction not to
Yes.
delink?
not to link.
Where is it?
It was on 8/4/2008. It was initially on 8/3, 8/4, 8/2/2013 interim order. Thereafter, it was made final on 10/4/2013.
What is your evidence? What evidence did you give?
I laid evidence in that injunction violation.
Violation, what evidence did you give?
I gave that we could not, by technical demonstration, we could not go to the site.
Then?
That was rejected. They said that it was no. It was not within their knowledge, therefore it is cancelled. Therefore, there is no violation. Whether all along it was contested by them.
Now, the thing is like this. You are alleging something was telecasted on 6/8/2011. What is the policy for retaining those documents?
It is 90 days. 90 days.
You got the injunction on 8/2/2013.
On that day, it was there.
How?
We have demonstrated before the court also. We have demonstrated by way of our system before the court.
Very well. Prove it.
Now, alternatively, if the court doesn't find that injunction of the violation, alternatively, we will be allowed to give in the secondary evidence by of the same system, which was we have the CD.
Look, if that is not there, you see, how did you get that document?
By uploading it, downloading it.
So, what is required to be done? You have to give a Section 65B certificate. Give it.
That is what is. In the limited, if this petition or court finds it.
What are you
yes,
saying about secondary evidence? This can't be a secondary evidence. It will be a primary evidence.
in that case, court finds it, yes. Because that content is very
If you
important.
are downloading,
Download.
you are downloading
Lordship.
a particular document,
Sir.
an electronic document from some site. If you have already downloaded it from
Yes.
your site, and it is now put in some floppy
Yes.
or what pen drive or whatever you mean, you need to give a certificate in terms with 65B.
Only thing, my problem is that whether this, whether violation has been completed or not. Violation has been done by the defendant number 1 and 2.
How are you saying that on that day you have not proved that as to on that day it was there?
Because by leading my evidence in violation petition, I have practically demonstrated that I could not go to the site.
It is a different thing. You could not go to the site. But did you demonstrate from your evidence that as on 8/2/2013 it was there? That is the question.
Lord, in that
Problem arises there.
in that lot that in that law, in that case, Lordship, I may be about by evidence file in the form of compact thesis that by this one may be allowed to be given, allowed to be
Who has asked you not to give?
not only given, it must be considered.
Why
So that
should I pass an order? You asked there. Give a certificate under 65P. Matter ends.
only the
Don't hesitate this matter any further here. Any order passed out here will be detrimental. You only make a submission that you would like to withdraw the appeal, and the observation made out here shall not prejudice the plaintiff in the suit. That is the one clever submission you can make.
Lordship, only thing in that case, they will twist the matter in another way that I could not put that contents. There was no such telling
Right?
us.
That is what you prove. You have see, if there is any electronic evidence, how do you prove? You have to prove it in terms of section 65A and B. So you have to prove it in that account. Your cause of action has arisen on 6/8/2011.
Yes, sir.
You got the injunction on 8/2/2013. By the time 22 years have already gone, or almost, and you have failed to prove that as on 8/2/2013 that link was available.
I also, because Lordship, that was a repeated telecast. Oh, that is why my problem was that it was a repeated telecast.
So repeated because you have to therefore download it. And download it and then keep it.
Till the time of granting of intention, absolute intention, they did not object, they did not say that there was no such telecast initially. That is why, as such, the
Oh,
latter
you
trial court,
take the benefit, Mr. Counsel. They have not denied that. In later on, under Order 39 Rule 2A, they are doing it. What are you trying to do out here is, you are trying to proceed in terms with Order 11 Rule 14 by way of an violation order. Do you know that the problem which you are going to face?
in that case, I'll leave it to your person.
You withdraw and say that the observations made in this order.
That will. Even other also, there is a 2011 matter, and the other CRP matter also may kindly be disposed of so that at least it goes back to the trial court for completion of the trial.
For?
Completion of the trial. Because of
Records are here.
No, Lordship, because of pendency of this FAO as well as CRP, suit could not be proceeded before the trial court.
Anyways, we first closed this today. And the CRP will be closed on another day whenever you feel like you ask
Only
them.
thing on the last occasion, honorable court decided that this will not be taken up by this.
Huh?
On the other day, in the CRP matter,
Oh,
the court decided not to
oh,
take this.
they said so. Yes, I remember that matter.
Yes, Lordship.
Okay, then I won't take up. Okay, is the matter before any other court.
CRP, I don't remember, but another
Lordship,
matter of
my
ours,
intention is
we
not-
made a mention before.
Is it connected with this suit? Did I
Yes,
say?
it's same.
Yes,
within the
that
same
was
parties.
filed by CRP, was
Within
filed
the
by
same
us.
parties.
Then
Within
you
the
have,
same parties.
you have got that order out there. How can I take up it?
Between the same parties are in.
We made a mention in the morning one.
First of all, you should not have done that.
Lord Monsing, I was morning it, I was also here. I-
No, I remember that day. Her junior mentioned that matter.
Today, my lord.
No, on that day. It was mentioned, it came as item number 2 or 3. It came out there, he mentioned that I may not like to take it up.
Lordship.
And I said it, okay, I don't know, you were there or not, I remember, but they said, if this is the connected one, I want it.
Today morning he mentioned.
But otherwise, Mr. Bhagavati, that is the problem. Hello?
We take it up after.
What? No.
Anyways,
Oh, this one you want to withdraw.
yes, they become infrastructure.
Why?
Lordship, because the title suit, it has been withdrawn by the parties, my lord, due to the settlement.
When?
It was disposed of on 31 of 2019.
31?
30
30 January 2019.
31, 2019. Okay. This is an application. This is the instant appeal arises out of the instant appeal is filed challenging the order dated 6/9/2017, passed in Mizze case number 104/2015, arising out of title suit number, which one?
Title to 66 of the
66/2015. Good stop. The learned counsel at the bar duly submits that the said title suit number 66/2015 have already been withdrawn by the plaintiff on 31/2019. So taking into account that the suit being not suit, taking into account that the suit is no longer alive, the instant proceedings have become infructuous, for which the instant appeal stands dismissed as it had become infructuous.
deeply operated.
Next.
Yeah, please, the doctor. Doctor, in this case, appellant number 1.
Who?
Appellant number 1.
Don't worry. We dismiss it on the other one. Defend number 1.
Yes.
Who is defend number 1? Who is defend number 1?
Appellant number 1. Devendra.
Don't worry. 2, 3, and 4 is there, na? Sons.
Other legal heirs are.
They are already there, na? 2, 3, and 4. Don't worry with
wife
that.
and the daughter are there.
Not necessary. Argue. Appeal can be continued. Defend number 1 is the father, 2, 3, and 4 are the sons. No worry. Start the argument.
Doctor, I would like
Withdraw?
to see the
Absolutely no. Was it not listed on last Thursday that these matters no adjournment? So don't come up with these excuses.
But I would like to call. I would like to call this.
Who is your senior?
There.
Huh? Bring him. What is this? You are asking against what? Don't come up with this type of. Oh, he made a mention also, I rejected it. Then also you have the audacity to again ask me? My goodness. What is that? What is the injunction you sought for? Brickfield. Yes, government. Brickfield. Why? Why the state government? Because it is against the state.
Yes.
Why?
There is sitting case, sir. 147 of 74.
Where is the plane? But now what is the status? Was there any injunction passed by this court?
No injunction.
Injunction,
There is an interim state.
Yes. There is an injunction of status quo as regards possession passed in 2018. So what is the status of the suit?
I have to obtain instruction, but it's a status, no, that.
Mr. Roy, what has happened to the suit? What
suit
has
is
happened to the suit?
Suit is pending.
What is the stage of the suit?
Stage of the suit,
We'll take it up after we have a full bench. After rising from the full bench, just let me know. I will let the status quo remain because already 5 years it has, say 6 years it is. Will direct the suit be disposed of as expedite. You just find out what is the stage of the suit. We'll take it up. I think that is the only thing can be done because the state seems to be not bothered. And if it is a private land, obviously you can't do anything.
it is a
So that is it.
patta land.
Huh?
It is a patta.
The patta land, then you can't do anything. But if it is not it's a government land because the trial court is led it as if it is a government land.
Yes, sir. There is a restitution. Direct a restitution.
So whatever may be,
Yes, sir.
earlier Mr. R. Bapujari appeared. Ask
Yes,
him
I
to
will.
be. Yes. Possession.
Yes.
And it is going on.
And my lord,
So let the status quo as possession remain till the disposal of the suit. And we direct the suit to be disposed of early. That's
because
the only thing.
yes, now my lord, in the IA, since in the FAO, my lord, no pleadings has been exchanged, of course. But in the IA, that is order 39 application, a written objection has been filed on behalf of the my lord opposite party, the state respondent, wherein a specific stand has been taken that the land in question which they are complaining of, my lord, are my lord filling surplus land. So that is on record. And my lord,
Then why did you give a sale permission for sale of the land?
no, my lord, in the written statement also filed down below in the file. So my
And
lord,
it is the suit is at the stage of
it is at the
PW.
They have file application for additional documents.
The suit was fixed at the stage of cross-examination of PWC. At that stage, my lord, the plaintiff have come out with an application taking the leave of the court to produce additional documents. To that extent, my lord, next date is fixed on 13th of June for filing objection by the defense.
Don't file objection. Certain things in the trial. Its trial is like a chess, which Mr. Roy knows how to play it very well. So certain things you have to give up so that the matter gets disposed of. See, when you know that whatever documents they may produce, because if you reject it, there comes a
Yes.
revision here, and the stay is being granted, and the matter goes for another 6 years,
Yes.
which doesn't help you.
Yes, absolutely, absolutely.
So you have to
Let it
play
be
it
tried
like
for
a
once and all.
huh?
Let it be tried for once and all.
Once and all and
Yes.
finish it off.
Yes.
As there was an injunction passed in 2008 as regards the possession, suit is pending its status advanced stage of evidence. Trial have started.
Will kindly fix the time limit of at least 6 months, my lord,
8 months.
or and you have to dispose of the entire suit.
Hmm.
Because there are on similar facts and circumstances which are part of the affair. They have already moved this honorable court. The honorable court has negated their claim. Matter went to the division bench. Division bench has negated their claim. Whereby, my lord, 18 notices under 18, my lord, the exercise to remove them under 18 was initiated by the authorities.
So then why the plea of section 154N is not being taken?
No, that is taken up there in the written statement, I am told.
You need to press it hard.
No, absolutely, my lord. So that was in respect of the
Wouldn't that be a
government land.
bar under Order 7 Rule 11D for rejection of the plea?
Difficulty is there, my lord, my lord, we are not in a position to conduct all the tests, my lord, effectively. That is, my lord, of the record. That is,
Therefore, the instant appeal under Order 43 Rule 1R, read with section 104 of the Code of Civil Procedure 1908, is directed against the order dated 15/9/2017, passed in case number 58/2017, whereby the application filed for seeking temporary injunction restraining the defendant from forcefully taking over the possession of the suit land was rejected. The case of the appellants who are the plaintiff in the suit is that they had purchased the suit land by registered deeds of sale. And as such, the said lands are private patta land, are patta lands of the plaintiff. And the respondent authority had no authority to take over the possession of the suit land in the manner which have been sought to be done. It is under such circumstances the suit was filed seeking declaration of the right. It is under such circumstances, taking into account the actions of the respondent in clouding the rights of the plaintiff, the suit was filed seeking declaration of the right title interests of the plaintiff, as well as for permanent injunction restraining the respondent from disturbing the possession of the plaintiffs over the suit land. Along with the said Act 2, which was registered and numbered as title suit number 30/2017, an application was filed seeking temporary injunction, which was parameterial, with the injunction which was prayed, permanent injunction as prayed in the suit. The said application was registered and numbered as
Mistake case number 58 of 2017.
58/2017. In the said suit, it has been brought to the attention of this court. Written statements have been filed by the defendants who are the respondents herein, taking the plea that the land is a ceiling surplus government land, and as such, the deeds of sale, if so any executed, had no force of law. It was also stated that that proceedings under Rule 18 of the Assam Land, under the settlement rules of the Assam Land and Revenue Regulation 1886, were duly taken up against the plaintiffs, and the plaintiffs have duly challenged those proceedings before this court, before the High Court, before this court, which were negated by this court. It was therefore the specific case of the respondent that the suit was not maintainable, and the plaintiff could not have any right, title, and interest over the said suit land. The learned trial court, while taking up the injunction application, dismissed the said application on the ground that this court, in its order dated 12/8/2016, held that the occupied land measuring 14 bighas 2 katha 2 lechas of Deban Das and his 3 sons are ceiling surplus land, and their vendors had no legal authority to such sale to the current occupiers. Likewise, the 26 bighas 3 kathas 17 lechas of land occupied by Raj Kishore Ray is also ceiling surplus land. On the basis of the said observations made by this court, the learned trial court came to an opinion that the petitioners, the plaintiffs, did not have any legitimate right over the occupied land, and as such, the question of granting an injunction did not arise. Being aggrieved, the instant appeal has been filed. Alleging, raising various grounds and objections as regards the legality and validity of the said order. Along with the appeal, an interlocutory application has been filed, being IAC 169/2018, seeking temporary injunction, which was prayed for before the learned trial court. The record revealed that this court admitted the said appeal, instant appeal, on Nine 3/2018. On the same date, no, 9/3/2018. Subsequent thereto, on the same date, in the injunction application being IAC 169/2018, this court issued notice and observed that the prayer for interim relief would be considered on the next date. Matter was listed on 13/6/2018. However, as on that date, as there was no objection filed, this court, as an interim measure, directed that the status quo as on 13/6/2018 as regards the possession of the land shall be maintained until further orders. This court further takes note of, while hearing the instant appeal, this court had inquired with the learned counsels appearing at the bar as to what is the stage of the suit. It has been duly informed that the suit is at the stage of cross-examination of the plaintiff witnesses.
Yes, my lord.
And the next date is fixed on
13/6/2024.
13/6/2024. Taking into account that there was a status quo order passed by this court almost 6 years back, and the same have been continuing till date, and the suit is at the advanced stage, this court is of the opinion that the said order of status quo be maintained till the disposal of the suit. This court, however, makes it clear that it continues till the disposal. Accordingly, the instant appeal stands disposed of with the direction that the parties herein shall maintain the status quo as regards the possession, title, possession, as well as the nature and character of the suit land till the disposal of the suit. Mr. R. Golpuzari, appearing on behalf of the respondent, submits that there has been considerable delay in the disposal of the said suit, taking into account that almost 7 years have passed by. This court passed by, and the government and the land being a government land, the necessary infrastructural need cannot be accomplished on account of the delay in the disposal of the suit. This court, taking into account that the suit had been pending for the last 7 years, is of the opinion that an expeditious disposal of the suit is required for the ends of justice. Accordingly, this court requests the learned trial court to dispose of the said suit as expeditiously as possible, and preferably within 8 months from the date of 8 months from 13/6 to
13/6/2024.
2024. In that process, if need be, the learned court, trial court shall also take necessary measures of taking up the matter on day-to-day basis. With the above observations, the instant appeal stands disposed. IA, in view of the order passed in the order so passed in view of the order passed in so and so, the instant or interlocutory application stands disposed of in terms with the order passed in the main appeal in F1.
Apply.
Who was the sole respondent in the trial before the trial court suit has died, and
Who died?
the appellant died, my lord.
When?
Before your sometime in, and for that, my lord, I have already filed an application for bringing in record the substitution of the appellant's years, my lord. And that is also numbered as 3208 of
What has happened to the suit?
suit is going on, my lord.
You got an injunction,
No, injunction was against me.
status quo.
Status quo was there.
Then,
And the suit is proceeding.
when did you file an application?
This for substitution, my lord. It was filed on 13/3/2020.
13/3/2024.
And I'm informed, my lord, in the original suit, my lord, my clients have informed that they have already been substituted there.
Mr. T.P. Solia, the learned counsel appearing on behalf of the appellant, submits that the sole appellant had expired. He submits that applications have been duly filed on 13/3/2024. 13, na?
My lord.
13/3/2024. So, taking into account the above, list this matter again on 15th of May 2024, along with those applications so filed.
Well,
Yes, what is this?
May it please your lordship. My lord, this appeal your lordship find, my lord, is against the impugned judgment and decree, my lord, passed by the Transfer Appeal Court, deciding all the issues of the for one plaintiff, having the decree, and thereafter, my lord, remanding the case.
In view of the discussions and points where appeal is allowed on contest, the impugned judgment and decree passed by the is set aside and the suit is remanded to the appropriate after
All issues were decided in favor of the plaintiff, but court says, my lord, ultimately the matter should be remanded to the trial court to decide the issue as to whether the plaintiff responded with saving differential right over the suit left. Now, that issue was also decided by the appellate court, my lord. Now,
Where?
what the trial court will do?
Issue number,
My
point number
submission
2.
is that, my lord, if there are, my lord, enough evidence which, my lord, give right to, my lord, the Landed Lower Appellate Court to decide this. Landed Lower Appellate Court ought to have decided the suit, my lord, order 41/24. There are sufficient evidence here. Now, here in this case, your lordship will find from the plain, my lord, where your lordship will find that based on
Now, why the first appellate court could not decide this?
that is our ground, my lord, one of the ground.
Why?
If appellate court decide, I have no objection. Lord.
And that is it. He set aside this. What is this? He did not say that the reason is not that the evidence of witness clearly indicates that the heir has residential house over Iman and she is the co-sharer of the Iman. As such, the claim of preferential right of Iman is required to be considered afresh and independently by framing. Why is it required? There's already.
This is the only thing, my lord, and issue number 6, trial court has decided that already, my lord, on the basis of evidence in the case record. And
I am the
court,
plaintiff,
appellate court,
lordship.
my lord, while deciding, my lord, issue number, my lord,
But
point.
there was no
number 2
issue as regards preferential right.
Yes, lordship. That
What
is
was the preferential right?
differential right, my lord, he said that he had the preferential right to purchase the institute to land. Our case is that, my lord, case of the plaintiff respondent, my lord, his land belongs to their other expired, behind the daughter's here. Now, our case is that, my lord,
You are the plaintiff.
I am the
I am the
defendant number one of the sister, my lord.
You are the
I am
plaintiff.
the plaintiff.
Yes, you are.
As
What was
section,
your case?
section 22 preferential right in to acquire property in certain cases, Hindu Succession Act 1956, lordship. Where after the
No,
commencement
no,
of
it's
this-
okay. But what is your case?
my case is that, lordship, with meets and bounds, it was not demarcated. We three sisters are residing over the entire plot of land.
Hmm.
So they have the defendant number 1 illegally, lordship, sold out the land where I am residing.
Hmm.
So I may be, there is a threatening to disposition of the.
Tell me what is your
My
relief
lord,
claim in your suit?
Page 22, my lord, plenty there
The
could play the
declaration of
key.
the first schedule is still
Bottom line.
remains as my leave for
Paragraph
declaration
11.
of the defendant has no right to alienate the suitor in any thereof to any other person until partition takes place. Has preferential right to purchase the residence here. This is required.
That
There is no issue as to whether he has a preferential right or not.
Lord, issue
That
number
was
six,
not
purchase the
Lord,
respective.
issue number 6 was decided by the learned trial court, your law.
Issue number 6 is what? Whether the third cylinder is collusive
Now, in issue number
fraudulent
6, my
document.
lord, last part, your lordship may kindly see.
in
It
Esmali,
was
issue
decided
number
by the-
5, lordship, whether the plaintiff defendant number 1 and pro forma defendant number 7 are the owners of the first scheduled land in Esmali having right title interest, that is the common
No,
issue,
this is
lordship.
not the issue.
My right was not formulated.
Issue was for preferential right.
My lord,
That
page
was not
54,
formulated.
paragraph-
Because then only she can get a right of purchase. You don't have a right. You want a right of purchase.
Yes, lordship, the preferential right, that issue was not formulated.
My lord,
If
your
lordship, first
lordship,
appellate court
issue number
itself.
issue number 6, it was discussed. Page 54, my lord, of the trial court judgment, your lordship may kindly see. My lord, paragraph 55. Page 54,
Page.
page 54, paragraph 55. Section 22(1) excluded that one of the conditions for applicability of section 22 is that when an interest in improved property of a state devolves on 2 or more heirs classified class 1 heirs and one of such heirs proposes to transfer or interest in the property, the other share shall have preference over the interest of proposed to be transferred. And ultimately, by discussing, my lord, page 55, paragraph 56.
You are the plaintiff.
I am the plaintiff.
Now, my lord,
What is your ground of objection in respect to this paragraph 55 to 57 of the trial court judgment?
I am saying that, lordship, it was not partisan. We all are jointly holding.
No,
that
in your grounds of objection when you took it in the first appeal, where is your grounds of objection? Appeal?
title appeal memo not annexed, lordship.
No, I'll do you.
Grounds of appeal, your lordship will find page 64.
Page
64, lord.
64.
In the appeal memo, the appellant plaintiff raised the grounds amongst others the learned as heard in law as in fact but failed to apply the judicious mind. Decision of issue number 5 arrived at by the learned lower court is perverse and bad in law. The lower court failed to consider the fact that there was no partition of the first scheduled land by Meads and Law.
Failed to decide the issue number 6 properly and misread both the law and fact. Failed to consider the fact that the plaintiff has preferential right for a It was never your ground. That as well as they say decided as bad in law. So you were never aggrieved by the fact that there was no separate issue in this point.
No, lordship, the partition point I have
No, on preferential right. That was never your objection.
lordship in later part, the issue number 6 properly and misinterpreted both the law and facts. Learned lower court failed to consider the fact that the appellant plaintiff have a preferential right.
Huh?
my lord,
That was a ground, lordship.
No, you have taken the ground. It
Lordship.
is not your ground that there was no additional issues framed, and as such, I am not able to give evidence. That was not the ground.
But that preferential right was not discussed by the learned trial court, lordship. That was
It was discussed 55 to 57.
55, 56, and
Maybe not properly.
57.
That's a different thing.
lordship.
But the fact is that you never say that, look here, that preferential issue was never framed, and for that I have not been able to adduce evidence. And that is the result of a miscarriage of justice. That is never your case. And let's see.
I was reading my lord paragraph 55. Thus, in order to attract provision of section 22, it is one of the conditions precedent that there must be an existing interest over the immediate which devolves upon two or more where is specified in
Yeah.
clause.
What the learner ought to have considered that the plaintiff appellant is the first preference of the schedule of the class 2 heir of the imam, and so is entitled to the share of her sister's so under section here. So that is your only thing. Issue number 14, grounds of objection number 14
Lordship,
in the appeal.
Lordship, title appeal memo I thought that.
Have it? Please.
Only your lordship, if the first appellate court itself decides this issue, lordship, I have no objection.
That is what I am saying. I am not going to decide it.
Lordship,
The only question is whether it is a case of remand or it is a case where the first appellate court could have decided.
first appellate court, lordship, it itself can frame an
Absolutely.
additional issue, lordship. That can be done by
Now,
the
irrespective of that,
Lordship.
can very well have a point of determination which it had.
lordship.
Only thing that the first appellate court ought to have decided it.
Lordship, in that case, I have no objection,
Issue
but they have taken some other grounds also. On
Issue-
merit, if your lordship, they have taken some grounds on merit also,
No, merit I am not going to touch.
lordship.
Here I am only touching on, I am setting aside the judgment
Lordship.
and remanding it back for the fresh decision on the basis because this order has to be set aside.
Lordship, I am plaintiff. If first appellate court
This
decides, I
order
have
has
no
to be
objection.
set aside and the trial court has to decide, the first appellate court has to decide
Lordship.
on the
Let
basis
it
without
decide to
remanding.
come, my lord, if we are agreed, second appeal is there, my. Why, my lord, again to send it to the Chief Court, time taking affair, my lord,
No. I'm not sending it to Municipal Court.
not yourself. I am saying about
Yeah.
our appellate court.
Therefore, isn't that only ground?
Lordship, I can direct that an additional issue or an point.
No, they have already had the point of
It is
determination.
already
Lordship.
there.
If they want to have it, how many points of determination? Let him have it. But he shouldn't have it. Therefore, this is an appeal under section 104, read with order 43, rule 1U of the Code of Civil Procedure 1908 against the order dated 19/12/2018, passed in title appeal number 11/2018, whereby the learned first appellate court and what is this? A decree may be prepared accordingly. This judge doesn't know that a decree cannot be passed against an order of remanding. Whereby the learned trial first appellate court, that is the court of the civil judge Karimganj, had remanded the suit back to the learned trial court by framing an independent issue in respect of the claim of to the learned trial court for fresh disposal after framing an independent issue in respect to the claim of preferential right of the plaintiff. This court further finds it relevant to mention that the learned first appellate court also observed that there should be a decree be prepared. But however, the question of preparation of a decree does not arise in as much as when an order is being passed, in as much as when a suit is being remanded for a fresh disposal, it would be a suit coming within the ambit of, it would be a remand in terms with Order 41, Rule 23A of the Code, and as such, it would be a order. Under such circumstances, the said direction of preparation of a decree is completely unwarranted. Be that as it may, this court have duly taken note of the copy of the plaint, the written statement, as well as the evidence on record. This court have also taken note of the judgment passed by the first appellate, the learned trial court, wherein, more particularly at paragraph number 55, 56, and 57, the learned trial court, while discussing the issue number 6, have duly dealt with the preferential right of the plaintiff and held that the plaintiff did not have the preferential right. The first appellate court, however, the learned first appellate court, however, though, framed the point of determination as to whether the claim of the preferential right of the plaintiff to purchase the share of the co-sharer from the suit land was justified. But surprisingly, remanded the suit back to the trial court for formulating by frame an additional issue as regards the preferential right over the preferential right of the plaintiff. Though the learned first appellate court could very well decide the same, could have decided the same in terms with the evidence which was already there on record. This court have also taken note of the grounds of objection which was taken by the plaintiff as an appellant before the learned first appellate court. And more particularly, the ground of objection number 14, wherein it has been only stated that the learned trial court ought to have considered that the plaintiff had first preference of the schedule, first preference of the schedule of the class 2 heirs of the deceased father, and as such the plaintiff was entitled to get the share of her sister, principal defendant number 1 oblique the respondent number 1, being preferential right under section 22 of the Hindu Succession Act 1956, which the learned trial court committed an error in deciding the issue number 6. This court, having taken note of that there was evidence on the basis of which the learned trial court, first appellate court, could have decided the said issue, and ought and issue could have decided the said aspect. But however, the learned first appellate court, contrary to the provisions of Order 41, Rule 24, had remanded the suit back to the learned trial court, which, in the opinion of this court, was not justified. Accordingly, this court set aside the judgment and order dated, impugned judgment and order dated, impugned order dated 19/12/2018, passed in title appeal number 11/2018, and directs the learned first appellate court, that is the court of the civil judge Karimganj, to decide the said appeal afresh. The title appeal number 11/2018 afresh on the basis of the materials which are already there on record. Why? It is already there. It has the preferential issue has already been formulated. Madam, point of determination number 2 is there. Kindly see that. Preferential interest. See, it's already there.
Already there. Point number 2 here.
Number 2, whether the claim of preferential right of the owner was purchased is also. That is already there. Why should I say anything? That is your lookout.
PW2 and other evidence are there.
I am not going to say anything. This court, taking into account that the parties are duly represented, this court directs the parties to appear before the learned trial court, before the learned first appellate court, that is the court of the civil judge Karimganj, on 1st of July 2024. The registry is directed to forthwith transmit the records of the case, to the learned trial court, First appellate court, that is the court of the civil judge, man, Karimganj. Forthwith. And if necessary, take recourse to a special messenger so that on the next day it's so fixed that learned first appellate court is in a position to take up the matter. Yes, Mr. Muzumdar. What matter? What is that? Second appeal? What second appeal? Earlier I had heard it. Then why it has come? ওই যে পাঠার ওই তো কি মানে কে গুলো এন্ডর তো হয়ে গেল 13. Mr. Sharma, your matter. What is this SAO for? These small SAOs are needed.
This SO is against the allowing the appeal. The facts of the case is like this. A suit was filed against the appellant for declaration of right title interest and